Welcome to the Insurance Guy Podcast. From sales to insurance advice, we discuss ways to protect your business and grow it. Make sure to like and share this podcast. And don't forget to check us out at theinsurers.ca for all your business insurance needs. And here's your host, Mr. On.
Every fact pattern has unique circumstances. Mr. Kermalli is not providing legal advice as part of this podcast. Please be sure to contact your legal and insurance professional to obtain advice on your particular matter.
Welcome to the Insurance Guy Show. It's your host, Mr. On Japanwala, the Insurance Guy. Today with me, I got a corporate lawyer with me, Mr. Ali Kermalli. First of all, Mr. Ali, thank you so much for joining us.
My pleasure.
So today, let me actually give you a little insight about Mr. Kermalli here. He's been 17 years in the legal field. He's currently a partner at Loopstar Nixon, as well as he's spent the last 10 years working in-house within large companies, dealing with commercial matters with a goal specifically to help build their businesses. So we're going to be talking, today's topic of discussion is commercial contracts, and we're going to be getting into should a lawyer actually review them? Do you need to pay a lawyer to get involved, especially when you're dealing from business to business? Or are standard contracts going to be sufficient? And so let's get into the gist of it. Mr. Ali, let's get into this part. So as a commercial insurance broker myself, I meet a lot of clients who are dealing with businesses, and they'll have their contracts. They whenever dealing with a bigger corporation, especially the smaller guys, the contracts are usually presented from the bigger guys to the smaller guys, and they'll always say it's a standard form. Does a lawyer need to be involved in reviewing a standard contract?
Right. I would say so, yes, because what is a standard contract? Just because something is well formatted, justified on both sides, and in 2-point font doesn't mean that it's standard. In fact, is there really such thing as a standard contract? All that means is that it's a template, and it's standard contracts when they're presented. I get this all the time. Clients will come up to me and say, "Can you take a quick look at this?" I took a read through. It all looks really standard to me, right? Because there's a lot of legalese, right?
Yeah.
And when I review it, it's standardly one-sided. Right. Against the client. And what happens is, to look at it from another perspective, when I'm asked to put together templates for my clients that they then present to others, the exercise starts off as often, we want to be protected. Right. We do not want to be too one-sided. Right. So you end up drafting something, working through the options with the client. What you end up with is a template that looks very standard, but is very one-sided for the client for whom I drafted the document. And that is typically the case. So when the client or the enterprise is presented with a contract that looks standard, in fact, usually is very much against the person or the company that it's presented to. Okay. So absolutely you do want it reviewed, and there's always an opportunity, unless you're buying Office 365 or what have you. You have the opportunity to negotiate and have important provisions in there augmented so that they aren't as one-sided, depending on the bargaining, the relative bargaining power between.
Right. That's really important, especially in the rounds of negotiations. Correct. Because if this is a customer or a client that you really, really need, and they're the ones presenting you with the contract, you could possibly endanger the contract itself if you come up with your own contract for the other party to sign. Right. They may say, "Listen, you want this product? We're the only guys supplying this product. You play by our rules."
Right. Well, that can work on the supply side or on the customer side.
Yeah.
It's a big client. That client can go to. You have competitors they can go to. Right. And so when that happens, the exercise is very different. It's a review of the contract, pointing out the red flags to the client, telling them sort of the 3 things that we should try to have changed if we can, and find a discreet or subtle way to do it where it's not just redlining it. Right. And then pointing out the other 5, 6, 7 items that the client can mitigate through measures internally. Right. Including coming to someone like yourself, and perhaps beefing up their insurance policy.
Yeah. Right. Yeah. So like let's say someone gets there, you're a small business owner, like a lot of my clients are, and they're dealing with somebody, let's say it's a supply and it's a buy and supply contract. At that point, the third party that they're dealing with sets forth a contract that's heavily in their favor, that puts our guys at risk if things go wrong. If that takes place and it ends up in a court system where there's a really significantly one-sided document or contract in place, would the court hold up? Would the contract hold up in court?
I mean, generally speaking, every set of facts is very different, of course. But courts are not looking to tear apart contracts, except in sort of really egregious circumstances. And I mean, the clients that we're dealing with, we're talking about what they would call commercially sophisticated parties, who would have had the opportunity to, there's no gun to their head, they get the contract reviewed and negotiate. Again, there are exceptions to this, but generally speaking, a contract's a contract, and you're going to want to make sure that you're comfortable with the risks that are that flow from the terms that you're agreeing to.
And the reason I specifically wanted to ask that question is that I've had prospects where they would sign the contract and they would tell me that they were under this notion of belief that if it ends up in court, the court will play fair and make sure that the contracts are broken up evenly. And I'm like, this isn't a charity case. They're going to play it. They're going to assume that you are of sound mind and with enough resources to be able to have this
and enough
reviewed.
Sophistication, right?
Enough sophistication
to know that you should hire someone, perhaps, right?
So it's extremely important to review the overall contracts, and I always recommend them. Recommend my clients that to make sure to get a lawyer involved before you sign it off, because if the contract is, let's say, X is going to be doing X number of services or whatever the case is, or if it's a term contract, you want to make sure that for those terms you're not biting your tongue every time you're supplying or buying or whatever the case is.
Absolutely.
On our end, we'll look at always ask them to send us a contract, because usually those clients the third parties will usually request them to be put on as additional insureds on their insurance policy and stuff like that. So that's usually when I get involved, and I'll review the insurance section or the indemnification section on their contracts, and then the rest of it I'll say, listen, at this point,
like we did a month ago.
Right, exactly. What we did a month ago. I'll review the insurance part of it. I know what products and coverages that these products will cover you, but everything else you should have it refer to a professional and have it properly assessed.
Yeah, I mean, you touched on a really good point there, and it's not something I plan to get into, but I think it shows sort of the synergy between having a good insurance broker and a lawyer, commercial line lawyer. I mean, first step, you're going to have your insurance, through a broker usually.
Right.
I've seen instances where the broker is fantastic, and I've seen areas where instances where the client has no confidence in their broker to have something reviewed.
Right.
The broker can really save the client a lot of money because they know the policies inside and out and are able to look at the provision and work with the lawyer and hammer through that particular issue in a much more efficient way than a lawyer would, who has to, you end up paying for the lawyer to review all their policies, know them inside out, then review the contract. I mean, the lawyers now spent 10, 20 extra hours trying to figure out the policies and get through that. And of course, lawyers bill by the hour.
Yep.
So that becomes an exercise that's not efficient for the client. So having a good broker, I think, is really important, because you can cut a lot of those costs out, and you know the policies. The other thing I would say that's really important to have is not just any lawyer, is to have a lawyer that's got some experience when it comes to commercial matters in particular. I mean, a lot of corporate lawyers out there, and the lawyers that are trained here are often very good. But having that particular commercial experience, I think, is really important. What I end up finding is I end up talking through my clients through a lot of business issues. Because of my in-house experience, where I'm looking to help the company land the deal or find the right deal for them,
Right.
so that they can generate revenue, move their business forward, et cetera, but at the same time not regret the contract down the road.
Mm-hmm.
So you're trying to find that balance, and a good lawyer can help work with the client, work through the problems, and find the right risk tolerance level.
Right.
And with that, knowing the risk tolerance level, you can advise in a way that's not just in a sort of, pardon my reference here, but in a CYA type manner.
Yeah.
And I say CYA for the lawyers.
Yeah. Yeah, it's you're absolutely correct on that notion that we as even at both as professionals, we can't always, when we're reviewing, or for me, I have to make sure I review their businesses and see what their overall exposures are, and make sure that are they aware that they're going to have coverage for this, and this, and they don't have coverage for this, and this, and we find that we try to assess are you comfortable with this? What if the claim or the loss goes above and beyond this amount? Are you going to be okay to write that check to cover the difference? Or if your deductibles, are you comfortable with your deductible limits and stuff? So that's usually where I step in and take a look at it. Mm-hmm. And one thing I've learned in my experience is that no matter how much experience you have, you can only suggest these topics to your client, and it's the final decision is always up to them. You can tell them that, look, these points are something that I don't recommend having in your policy. It'll be held against you. But if the client is like, whatever, I want to sign this paper anyways, they made an informed decision.
Right.
But the last thing you'd want to do is make an uninformed decision.
Correct.
And regret it and going, I wish I knew this because I would have done so.
Well, that's what I mean by risk tolerance, right?
Yeah.
If you know what the risks are, you can make the commercial decision as to whether or not you're willing to tolerate and stomach that risk. But to sign up blindly and not know what those risks are, and I've seen that happen too many times where now you're in litigation and even frivolous litigation or litigation that's that's not going to go anywhere. Right. Can still cost you tens, if not hundreds of thousands of dollars. And all it would have taken is, a much smaller percentage to review that contract at the outset, or quite frankly, even to have a contract. Sometimes, folks enter into commercial arrangements without proper paperwork, or any paperwork.
That's
and now you're trying to reinvent the wheel, trying to figure out what the intentions of the parties were at the time of entering into the arrangement. And that's an expensive exercise in the court system.
A very resource demanding exercise.
Correct.
And
it's distracting to your business too.
Yeah.
Right?
you gotta dedicate the manpower. You're dedicating the financial resources on there.
Right.
It can pull away from potential sales that you're making. And
Sure,
so forth.
absolutely.
It can
See it all
be
the time. See it all the time.
And I get it. Like I've seen people, and I have seen it with my own eyes, where clients will do a deal with their best friend and say we shook on it.
Right.
Great, but you guys might have the best relations and so forth.
Correct.
However,
That's during the honeymoon period.
Right. And once the finances started to go back and forth, and the product's going forth, and then there's expectations, and you're like, well, I wasn't agreeing to this expectation.
That's right.
Those things can start leading up into a
and I've had situations where the clients are like, you know what, it's principled, let's fight, et cetera. And then after a year or so, and look, that's natural. I think everyone goes through that when you're in that situation. And by the end of it, they just want to move on with their business.
Yeah.
Right? And that's again a very natural approach. All of which, I shouldn't say all.
Yeah. But a high
most of
percentage
it, exactly, can be avoided by a good review.
By a good review or a good contract setup, right? Don't. The point of this is that don't cheap out on not having a good lawyer review or draft up a contract. It may look like unnecessary expense during the start of it, but if there are complications or conflicts arising later on, it can prevent a bigger expense later on down the road. Right. Especially when everything's laid out, agreed upon, it's an unnecessary hassle that's not needed. And if you are planning to sign a contract, if you already have a contract in place, and you need to reassess it, especially the insurance or the indemnification side, you probably have an insurance broker who originally helped you set up the policy for your business. Mm-hmm. Give them a call, have a discussion, ask them to review it. they can look at that part and at least make sure that if who's taking the brunt of the loss if things go wrong.
I think you work with a lawyer then to point out where the gaps are, and the lawyer dealing directly with the insurance broker. I can't tell you how beneficial it is for me.
Excellent.
To have that one-on-one discussion.
Yep.
It's not a make work exercise. It actually saves a lot of money, right?
Big time.
And the client doesn't have to be the translator in between.
Yeah.
And frankly, most business enterprises don't really want to deal with insurance or legal matters. Just let the service providers who you hate dealing with deal with directly. Right?
That's what happened a month ago. Hey, this is on meet Ali, and Ali meet on. Yeah. This is the situation. Good luck with this.
Yeah, exactly. And we sort of did.
Yeah, which was excellent. So, have you ever seen people agree to something that they don't have control over at a later point?
Well, sure. I mean, you do. It happens. Okay. In an ideal world, and this is. You're looking to the principle, and this really works well in negotiations, right?
Okay.
To say, look, I'm happy to agree to difficult terms, but I shouldn't be on the hook for something I don't have control over.
Right.
And this manifests itself in various types of provisions in contracts, particularly in indemnifications, right? And of course, if I'm delivering a widget, I'm going to be responsible for that widget.
Right.
But I can't be responsible for elements or use of that widget that I don't have control over. Right. That's a hallmark I sort of hang on the door and try to live by that mantra.
Okay.
So in a negotiation.
So what else would you suggest? So if someone comes to you with a contract that's been proposed to them, what are some things that you would review and suggest to the clients?
Sure. I mean, read through the contract, of course, and there'll be elements that jump out that are different in every scenario, but a few sort of general categories. Okay. You're going to want to look at, as we talked about, the indemnification. Right. And I think a detailed discussion on indemnification is a podcast in and of itself. So we won't get into that. Bottom line is, get comfortable with the areas of exposure, right? Or determine the areas of exposure where you're not comfortable, and try to negotiate those out or down. But again, limit your exposure to areas where you've got control. It's a very easy way to manage these various risks. Is have a limitation on liability.
Okay. Right? A limitation on liability. Okay.
Right. So you'll have a clause in there that says no matter what the damages are, or however the damages arise, your max exposure under this contract, you can make it mutual if it makes sense. Usually it's with respect to the service or product provided.
Being provided, yeah.
Right. Is that you're and it's common in the services industry as well, in the software industry, is to limit your liability to some percentage of the fees that were paid to you. But generally speaking, what I found in negotiations is that the client or the service provider will not want to expose more than they were actually
more than what they paid. Yeah. To add to that point is that if you're a small business and you do have a commercial policy, and if you're reviewing it, you may see numbers like you have $2 million for your commercial general liability.
Right.
However, you have to sit down and talk to your broker and find out what that exactly entails, and if that $2 million liability is going to respond for a service you may be providing. Mm-hmm. You may not need commercial general liability. You may need errors and omissions for any services that are being provided. Right. That's a very common misunderstanding, that people think that the liability will kick in if there's a service being provided or advice being given or
may not cover fire in their premises, that sort of thing.
Exactly. So there's this common thing that it's $2 million. It covers $2 million of property.
Everything. Yeah, exactly.
No. There's different aspects. There's different parts of your policy. Mm-hmm. There's coverages for crime. There's coverages for your property, your stock, equipment. If your business goes down due to an insured loss, how much are you covered for? These are all things that you should be reviewing. And the last thing you should be checking out is the coverages you need, and have your broker find the best price for those coverages your business needs. At least the last thing you'd want as a business to save $1,000, you're suffering a loss of $20,000. I had a client who had that exact thing. He specifically wanted to pay this much. Right. I advised him about the coverages that he needs. He said, "Nope, I don't need it. This is all I need." And his property cause, unfortunately, was damaged, and his insurance company just gave him for the check for the amount of coverage he wanted, not what he actually needed. And he shorted himself out by almost $30,000 to save $500.
You never want to, I shouldn't say never, but I almost will say never,
Yeah.
want to accept liability for consequential, special, or direct damages.
Yeah. For the people who don't know what that means, what does
Sure.
that mean, coverage
So-
for consequential damage?
Basically, it's anything other than the direct set of damages.
Okay.
So to put a sort of simple
Right.
explanation to it, it's obviously basically it's anything other that extends to, it can extend to loss of profits, goodwill, that sort of thing. It should be limited to sort of direct damages.
Direct damages.
Essentially.
Right. So just to give an example on that, if I was to supply you with widgets, okay,
Right.
I'm supplying you these widgets got in a one supply of, I supplied you these widgets and you got the supply and the supply batch was bad.
Right. I'm not going to pay for the fact that your company now is worth 10% less because you've got
This was a
outside
bad
clients.
widget. So
Right. It's
your coverage, you're saying, like part of the negotiation would be, listen, if I'm supplying you this widget and these widgets are bad, I'm responsible to replace these widgets or
Sure.
give you credit or whatever the case is.
Sure.
But I'm not going to replace. My contract's not going to entitle you to the loss of the widgets plus any damage of depreciated like reputation or whatever the case is.
Good way to put it, yeah.
Okay, perfect.
So the other thing I would say is look at your warranties, right?
Warranty, okay.
So warranties can have two different meanings in contracts.
Okay.
I'm going to focus on sort of the more traditional meaning that people will think is the traditional meaning. Is
Okay.
sort of, you buy a car and I get a 4-year warranty.
Right.
That sort of warranty. Often product providers will have standard warranties and you want to make sure that that's always incorporated in your contract and that there's nothing in the customer template or form that overrides your standard product warranties. That's critical, and I think a lot of manufacturers and product delivery folks will get that. Where I see a little bit less understanding is with respect to service providers or software providers.
Okay.
You want, especially where there's customization, what have you, and I think the software folks tend to get it as well. But you want to sort of set what the parameters are. Understand what the length of the warranty is, right? What the your reperformance obligations are, what the ramifications are if the warranty is breached.
Right.
How do you determine if it's breached? I mean, you could really draw it out and turn it into a meal of itself. I don't,
Right.
Again, the circumstances will dictate how detailed you get into it.
Right.
But you want something in there that has that puts some level of clarity to the standard to which you're delivering your service. State what the assumptions are.
Right.
If you are relying on it, cooperation by the customer or the client. Every sort of industry is different, but state what those are, and try to be as objective as you can in that service schedule or statement of work or however it is that you're papering it.
You'd say that should be part of the signing contract.
Absolutely. Is have very specific milestones. If it's a time-based milestone with assumptions, then state that. Right. Say on X date, this is what you'll get. If it's after X number of hours, then say that, and be on top of the hours and making sure that they're not just fooling around during those hours.
Have a log.
What I really like is a deliverables-based breakdown.
Deliverables. Okay.
So with respect to not in the legal industry, but
In contracts,
it can work in the legal industry too. But generally speaking, is when we deliver whatever it is that we're delivering, this element of the project, when it's ready for first testing, when final approval, et cetera, and then you can put in the contract sort of commitments by the customer to cooperate with that. So if they don't, cooperate within a certain period of time, well, then that can be deemed acceptance, perhaps. I mean, you can have provisions. It's very common to do that, so that you're not waiting for a client to give you that acceptance to get the last 10%, which is a big part of your margin often, right? Just the milestones, the payment milestones, should generally track the percentage completion, right? And if you're not sophisticated enough to understand what that is, then I think you got to do your homework and diligence to figure it out before agreeing to it.
Right. So overall, you provided a lot of tips. So quickly going over there is the things that you look for in a contract is reviewing the liability and the exposure, the risk exposure that a contract has.
Sure.
Also reviewing the warranties that the contract may be making, and if so, how detailed they are. Another part is to review the indemnification clauses.
For sure.
And indemnification clauses, as well as reviewing the insurance side of things.
Of course.
Mr. Kermalli, thank you so much for coming on the show.
Thank you very much for coming.
You provided a lot of information. Guys, if you want to reach out to Mr. Kermalli, how can they get up? How can they reach you?
You can go to our website, loonix.com, and look me up there. Or drop me an email at akermalli@loonix.com. And we'll reach out to Owen and he'll hook you up.
Thanks so much.
Yeah.
Until next time, guys. Take care.